the aggrieved party is freed from all his contractual obligations. What does it mean? You may either sit at home and you say, okay, we contracted and my friend has jumped out of it. Let me also ignore the contract. Or if you want to do it formally, then you can visit courts of law. You sue the defendant and the court will free you from all the terms of the contract. That means you are also no longer part of the contract. So rescission is like tit for tat. You have violated, I'm also violated. Let us look at number 5. Then I will also give you a summary at the end of my discussion on remedies. I will summarize it so that you understand them better. The last remedy, since there are 5, and we have looked at number 1, damages. Then we have looked at number 2, specific performance. We have looked at quantum merit. We have looked at rescission. Now let us look at another remedy. And that remedy we are going to look at is called injunction. Injunction. You should look for that point. Injunction. It is an order of a court restraining. The key word is restraining. Restraining is stopping. Restraining a person from doing a particular act. It is a mode of securing specific performance of the negative terms of the contract. What does it mean? You are about to violate a contract, and the plaintiff petitions or sues the other party. It means the court will make the party who is about to violate it not to violate it, restraining you from going ahead to violate a contract. That is what we call injunction. Members, let us summarize these remedies. Number 1, damages. And we have said damages refers to monetary compensation. Monetary compensation awarded to the injured or aggrieved party due to the loss suffered as a result of the actions of the other party. And I've told you that damages is not for punishment, but to compensate the injured party or the aggrieved party, so that he should be in a position like he was if the terms of the contract were fulfilled, or if there was performance and not breach. And we have said damages has types. For instance, has liquidated, has unliquidated, has pecuniary and non-pecuniary. Those are types of damages, and I've explained the meaning of each. Then we have looked at another type of remedies as quantum merit, a Latin word which means actual carrying out of the contract as agreed upon. No. Actually, that is an explanation for specific performance. Quantum merit means in proportion to the work done. Compensation in proportion to the work done. That means if one party violates the contract, then the party who has violated must compensate the other party the amount of money in proportion to the work he or she should have done if the contract was to be fulfilled. In proportion to the work done. Quantum merit. Then specific performance means actual carrying out of the contract as agreed upon. That means the court of law will now demand that the party who entered into a contract should actually carry out his or her obligation as agreed upon in the terms of the contract. Another remedy we have looked at is injunction, a restraining order, restraining someone or a party from breaching the contract. It means you have not yet breached, but your colleague has already seen signs of the party trying to breach. Then the last remedy, I've called it rescission. Rescission, it means resigned or cancel. If a party has breached, then the other party can also breach. Or if he wants the plaintiff for the aggrieved party, he seeks a court order freeing him from all the contract obligations so that he is no longer obliged to fulfill any term of the contract. I'm seeing someone raising the hand. You are allowed to ask before I can introduce something else. Any question? Any question? Any question? Okay, if there is no question, then maybe briefly, let us look at discharge of a contract. Members, you go to discharge now. If you know you have understood the topic we have finished, let us go to discharge briefly. Then next time I will also add on something. Discharge of a contract. What is to discharge? To discharge is to dissolve. When a contract is duly performed by both parties, then it comes to a happy ending and nothing more remains. Discharge of a contract means that the contract has come to an end. Let us look at ways or modes of discharging a contract. I'm going to summarize them. Then next time I will, because of time, I will summarize them for today. Let us look at discharge of a contract. Number one, contracts can be discharged by agreement. Contracts can be discharged by agreement. Contracts can be discharged by agreement. Discharged by agreement. What does it mean? When a contract I've started with agreement, when a contract is still executory, where each of the parties is yet to perform his contractual obligations, the parties may mutually agree to release each other from the contractual obligation. What I mean is that even if we are still performing the contract and we are two people have entered into a contract, for instance, me and you can mutually agree that let us stop here. Number two, contracts can be discharged by performance. Performance means that what we agreed to do has already been done, has already been accomplished. Therefore, the contract comes to an end. Number three, discharge by frustration. Frustration means something unexpected happens in the middle of the contract, which makes the fulfillment of the contract impossible, and the contract comes to an end. For instance, if one of the parties dies, in case of war, in the case of bankruptcy, etc., we call it frustration. That means that the contract has been frustrated by by something unexpected, like natural hazards, floods, earthquakes. That is what we call discharge by frustration. Then we also have discharge by breach. As I've said, breach also brings an end the obligations created by the contract. The innocent party may file for a remedy which we have called rescission, and the court will free him from all the contractual obligations, meaning that if a party breaches, then his counterpart can also breach. Breach also can lead to discharge of a contract. Then the last one is discharge by operation of law. This is where courts are mandated to look at the conditions, to look at the terms, and courts can also discharge contracts. For instance, if there is a lapse of time, for instance, if one of the parties has died, etc. So in summary, how are contracts discharged? By agreement, by performance, by operation of law, by frustration, and by breach. So in case they ask you that question, I've summarized. Next time I will even add on, and you also need to look at the cases. As I told you that pastoral, you need the cases. So when you say discharge by operation of law and you explain what you mean, then you cite a case. Case, facts, heard. for you to earn extra marks. Any question? Because today we have discussed remedies. We also looked briefly at discharge of a contract. But next time we shall continue. But I've said remedies are orders granted by courts of law. And they are granted by courts of law as a result of breach of violation of contract. And remedies are granted as a result of one of the parties whom we call the plaintiff seeking for the orders against the party that has breached, whom we call the defendant, plaintiff, defendant, petitioner, respondent. And we have said the remedies include, number one, damages, quantum merit, specific performance, injunction, and rescission. Then discharge of a contract, modes of discharge, we have said the contract coming to an end, modes include by law, operation of law, breach, by performance, discharge by frustration, etc. Members, if you don't have questions, I thank you, and I thank you for participating, and I encourage others also to participate, because e-learning helps students not to lose track, to remain focused. Otherwise, I wish you the best. May God bless you.